were outside and he asked me if I was getting drunk, and I said yes. And he didn't want me to go into the house because he didn't want me to wake up my mom.
Thank you. Good morning, everyone. We are on the record in the matter, case number. May I have your appearance, please?
Good morning, Your Honor. Lisa Szyc, 11726, attorney on behalf of the plaintiff who is present today.
Thank you. Good morning.
Good morning, Your Honor. Sheila Tajbakhsh, 15343, here on behalf of defendant. Excuse me, who's present to my left, along with my paralegal Ryan Collins.
Thank you. Good morning. Okay, this is the time set for the evidentiary hearing. I do see that we have our Nevada judges here present. Thank you, Mr. Falcone. I understand, I appreciate that you are blacking out the faces and the names.
Correct.
Thank you, sir. We appreciate that. And I see we also have some folks in the gallery. Can you please identify yourselves? Thank you. Maternal grandmother, Mrs.
Grandfather.
Thank you. Maternal grandfather.
Friend.
Thank you. Mr. Thank you. And do we have anybody else? I see you're with Mr. Falcone, I believe?
Yeah, Mrs. Falcone.
Okay, thank you, Mrs. Falcone. Okay, this is the time set for the evidentiary hearing. Before we go into the matters, I do want to let it note for the record that we have a full day today, 6 hours, 3 hours for each side. I will be accounting time, but you're responsible for keeping track of your own time. Anytime that you speak, it will be accounted to you. So if you're doing your direct examination, if you're doing cross-examination, if you're going forward, anytime that you speak, the time will be accounted to you. I've had counsel one time sit here and do 3 hours of direct examination, which left them with no time to do any cross-examination. So please, counsel, manage your time accordingly. At this point, I do see there are some preliminary matters, so you guys may be seated. I'd like to set a record on this matter, unless, let me ask, counsel, has there been any resolution?
No, Your Honor. Before we get started with preliminary matters, I'd like to invoke the exclusionary rule because everyone that was named in the gallery, they are named witnesses. So
Okay.
For that purpose,
Absolutely.
thank you.
The exclusionary rule is so invoked, Ms. Thank you for your time. Please stand outside. If you are called to testify, we will bring you in.
Thank you.
Thank you. Okay, before we proceed on the matter, I believe that it's very fitting, especially on cases such as this, that I establish the record and ensure that what I have is the same as what you have and what we have on the record, especially because I know that Ms. Tajbakhsh, you've been counsel since I've been over this case, but Ms. Szyc, you recently came on board, so I feel that it's necessary to establish a record in this matter. And specifically with regard to the motion practice, at least as far as the hearings that I have presided over. So the first hearing that I presided over, of course, this case began, as we all know, as a custody and divorce matter, and this case was initiated on February 9, 2023 by the plaintiff herein who filed her complaint for divorce and UCCJEA. We are dealing with the custody of one subject minor. For purposes of protecting the child's name, I'm not going to state his name, but we all know his name for the record. And his date of birth is. Shortly thereafter, she filed her complaint. She also filed a motion on 2/12/2023 for temporary custody, visitation, child support, spousal support, etc. That first motion was heard before this court. Of course, Mr. filed his opposition there too, and this court convened my first hearing over this case on or about April 6, 2023. On April 6, 2023, at that time it was brought to my attention, Mr. Schneider represented Ms. Tajbakhsh represented Mr. And it was brought to my attention that there was a pending criminal case, as well as the Child Protective Services investigation. In efforts to protect any potential inculpation in this courtroom, the court went ahead and continued the matter so that this court could order CPS records and could continue to convene the hearing with both parties. This court reconvened on May 18th, the continued motion hearing for Ms. which was her very first motion. By that time of May 18th, when we had the hearing, filed a second motion on May 16th with essentially the same arguments regarding custody of the child and regarding the safety and protection of the child, considering the underlying criminal case and matter at hand. Because the court received CPS records, the court advised counsel that CPS records were available, and counsel had to receive those records and sign their helper release. The court did release those to counsel once they signed the appropriate documentation. At the May 18th hearing, this court also recognized that while Ms. just filed her motion, because they were essentially the same arguments regarding custody, the court allowed oral arguments from Ms. through Ms. Tajbakhsh, who opposed it orally. And at that time, both parties did a sidebar, recognizing that there was an underlying criminal matter and any orders or any statements made in this court could be used against the defendant in the underlying criminal matter. It was agreed by both parties that both parties would not seek any new orders pending the criminal matter resolution, and that the temporary orders that were in place would remain in place, which was that the child would remain with mom primarily, subject to dad's visitation, which was supervised at that time. Notwithstanding the agreement of the parties at the May 18th hearing, it appears that on August 17th, Mr. filed an opposition to the May 16th motion that Ms. filed. That was August 17, and as a result of the August 17 opposition that Mr. filed to the May 16th motion, Mr. filed a reply on August 27 by Mr. Schneider. Mr. Schneider also, on behalf of Ms. filed a third motion on behalf of his client on August 31, seeking sanctions against Mr. for his August 17 opposition, because both parties had agreed at the May 18th hearing that they would not be seeking any new orders of the court. I put this in perspective because there was significant motion practice between the parties, and this court had several hearings. So at this point, this court convened a second hearing on August 31st at 10 o'clock, a few hours after Ms. filed her third motion. And at that hearing, this court addressed all the underlying records, including the fact that we already had a May 18th hearing addressing many of the significant factors that were underlying. So at this hearing on August 31st, this court did strike the reply, the August 31 reply that Mr. Schneider filed, because at that time there was some significant language that was inflammatory, highly inflammatory at that time. Mr. was still undergoing the criminal case, and there was no disposition, there was no final sentencing at that time, and therefore some of the language in the reply was premature, considering the underlying criminal case. The court went ahead and struck and agreed to striking the August 27, 2023 reply that Ms. filed, including the fact that the arguments were already heard by the court on May 18th. At the August 31st hearing, the court went ahead and heard Mr. Schneider's motion, which was filed on August 31 that morning. Mr. Schneider sought to sanction the defendant pursuant to NRCP 7.60 for filing the opposition to Ms. 516 motion, notwithstanding the fact that the parties on 518 agreed that they would not be seeking any new orders. So at that hearing on August 31st, the court went ahead, heard the opposition to the motion, which was already heard on May 18, heard Mr. Schneider's August 31 motion to sanction the defendant pursuant to NRCP 760 for filing an opposition to Ms. 516 motion, and the court also heard the reply to Ms. 516 motion and Mr. August 17 opposition. After the August 31 hearing, the court went ahead and also made some additional orders. At that time, it was brought to the court's attention that there was some further movement at the criminal court. And so on August 31, this court went ahead and, actually I apologize. The parties were not present on August 31 because of COVID. So it was only counsel that met with this court on August 31. But sure enough, with counsel had an excellent working relationship, professional relationship outside of court. And so it was agreed that this court actually decided to strike plaintiff's reply and heard Mr. Schneider's motion for sanctions against Ms. Tajbakhsh's opposition that was filed, which this court already heard on May 18th. So after the August 31st hearing, the parties came together again and filed a stipulation in order for this court to address emergent matters, because apparently, notwithstanding the agreements that were made regarding the supervised visitation in place and allowing dad to be able to contact his son through communication via text, there were some challenges that were brought to this court's attention. Both parties filed a stipulation in order, and the matter was brought back again before this court on September 19. On September 19, 2023, this court held a hearing to clarify the orders regarding defendant's visitation parameters and related financial issues, as well as methods of contacting the minor child from the August 31st, 2023 hearing. At that hearing, the court agreed that a mutual behavioral order would be in place. There would be no third parties at any of the exchanges, and the court did agree to lift, pursuant to the agreement of the parties, they did agree to lift these supervised visitation restrictions, provided that there would still be no overnights. Visitation was Saturday and Sunday from 9 a.m. to 5 p.m. And the court did also allow the grandparents to participate in the driving and the exchanges, provided that grandparents would also abide by the mutual behavioral order. At that hearing, the court also ensured that there were to be no guns nor drugs present during dad's visitation, and the father was not allowed to leave the minor child with any third party. The court further addressed temporary spousal support obligations, which was $1,000, and the need for mom to be self-supporting. The court also addressed medical bills, and that dad should pay for the additional $400 by the end of September, and any medical bills subject to the 30-30 rule. At that hearing on September 19, this court vacated the November 16 status check and moved it up to October 26 at 9 a.m. I believe this was because there was anticipation that the criminal case disposition would have been ready by then, and much of this court's work was contingent on the disposition of the criminal case. On October 26, the court convened its status check hearing from the September 19 hearing. At that hearing, this is the hearing where the dad requested to lift the supervised visitation restriction and to allow him to have overnight weekend on the weekends as well. The dad's attorney advised the court that there were no criminal restrictions on dad's visitation with his son, and therefore the court asked the mom at that hearing whether she had any concerns regarding the child, and the mother stated that her concern were guns. She advised that Mr. has access to guns, significant guns, and she wanted to ensure that there were no guns around her child. It was brought to this court's attention that he was not allowed to be near any guns, and he's not allowed to have any guns, and therefore guns were restricted from his contact with not just the child, but anyone. And therefore the court went ahead and lifted the restrictions, considering there were no criminal court restrictions, and it allowed dad to temporarily have weekend visitation. Mom asked for the third weekend of every month, so we left the third weekend of every month with mom. Every other weekend other than the third would be with dad, pick up Friday after school and drop off on Monday. Transportation would be facilitated by the grandparents. That was at the October 26th hearing. After the October 26th hearing, the next hearing that was inadvertently scheduled was December 19. On December 19, that was supposed to be, pursuant to Odyssey, the hearing on Mr. Schneider's motion that was filed on August 31 to seek sanctions against Mr. for filing in opposition, notwithstanding the parties' agreement that they would not be seeking new orders. However, that hearing was already addressed and heard on August 31 when this court granted the request to strike the reply and addressed the fact that both parties had agreed that they would be not seeking any new orders. Therefore, on December 19, because this court was unsure as to whether or not this hearing would be proceeding, this court followed up. Mr. Schneider was unsure because the underlying motion to sanction the defendant pursuant to NRCP 7.60, which was the motion that Mr. Schneider filed on August 31, that was already heard on August 31, and therefore this court did reach out to Ms. Tajbakhsh's office to find out whether or not this hearing was going forward. Ms. Tajbakhsh's office, through her law clerk paralegal, advised that they also believed that the matter was already resolved and the matter would be vacated because the underlying substance of the August 27 motion, that August 31 motion that Mr. Schneider filed, had already been substantively addressed. Notwithstanding, Mr. Schneider did state on the record that he would be seeking to set aside or strike a stipulation and order that this court signed that was not signed by him, and it was submitted ex parte. This court invited Mr. Schneider to submit a motion to strike, and this court will certainly entertain and review the motion to strike. Based upon my review of the record, I don't believe that any motion to strike was further submitted after that, nor was there any further follow-up So there was no substance, no orders were rendered, nor were any findings made at the December 19 hearing, which should have been vacated but was inadvertently left on calendar. That brings us to 2024. The matter was set for evidentiary hearing here on 2024. Switching gears, so I can go pull now the evidentiary hearing management order and switch gears to bringing, I believe that's when Ms. Szyc filed her notice of appearance for this matter as we went forward for the evidentiary hearing. 1 second while I pull up that. On September 15, 2023, this court issued its evidentiary hearing management order setting forth this trial. In the September 15, 2023 evidentiary hearing management order, which is an order of this court, and both parties and their counsel must abide by the orders of this court. It set the calendar call date for April 3, 2024, the evidentiary hearing date for today, April 19, 2024. It set a firm deadline for the memorandum and briefs of the parties to be due on March 27, 2024. It further stated on page 2 of the order that it's further ordered that all attorneys for litigants and litigants in proper person must appear in Department A, Courtroom 2 for this calendar call at the date and time set forth above, which was April 3, 2024 at 10 a.m. in big, bold, and italicized letters. It says failure to appear at calendar call may result in case conclusion sanctions consistent with EDCR 5.605D and EDCR 5.102M. It further goes on to talk about failure to provide a foregoing, which is the pretrial memorandum and exhibits, may result in exhibits being excluded or other appropriate court-imposed sanctions against counsel or party in proper person. Failure to submit the brief or memorandum on or before the due date, absent the court's approval, may result in the date being vacated and the matter being rescheduled in ordinary course. This is the evidentiary hearing management order which this court signed and issued, and parties are subject to it as well as their attorneys. Now we'll let the record reflect that this court did convene its calendar call as stated on the evidentiary hearing management order on April 3, 2024. Whereas the defendant did show up with his counsel, we'll let the record note that the plaintiff and her counsel, Ms. Szyc, both failed to appear for the calendar call, notwithstanding this court's very clear language in the evidentiary hearing management order, which states that failure to appear at the calendar call may result in case conclusion sanctions consistent with EDCR 5.605D and EDCR 5.102M. The court further finds that at the calendar call, whereas in the past this court has moved forward and proved cases up and convened matters at calendar call with counsel's failure to appear, in the interest of giving Ms. an opportunity, the court did not do case conclusion sanctions at the calendar call, though it was requested by Ms. Tajbakhsh, and the court did state that the trial date is firm, notwithstanding the plaintiff and her counsel's failure to appear at this court's calendar call. At the calendar call, Ms. Tajbakhsh brought to the court's attention that she had filed an ex parte motion to strike the pretrial memorandum that the plaintiff filed in this matter due to language that was inflammatory and in violation of the court rules as well as the Supreme Court holding in Rome. The court did note that Ms. Tajbakhsh's objection was filed with the court, and it did note that there was service was duly rendered on the date that she filed it, which was April 2nd, 2024 via electronic service. The court notices that the certificate of service on Ms. Tajbakhsh's ex parte request to strike plaintiff's pretrial memorandum filed on April 2, 2024, and objection to plaintiff's untimely disclosure of witnesses and for sanctions pursuant to EDCR 5.219 and Roe versus Roe was filed on 4/2/24 at 1:27 p.m. with the certificate of service evidencing electronic service to at backuslaw.com, to at backuslaw.com, and to at backuslaw.com. I presume that's your address, Ms. Szyc?
Yes, that's correct.
Okay, thank you, counsel. And so the court does find that service was rendered the day prior, notwithstanding the fact that service was rendered the day prior. The court does find that Ms. Szyc failed to appear at the calendar call where this court did hear the objection on the record. Notwithstanding the fact that Ms. Szyc failed to appear and Ms. Tajbakhsh requested for the entirety of Ms. Szyc's pretrial memo to be stricken, the court denied Ms. Tajbakhsh's request and actually went through the pretrial memo line by line, page by page, with Ms. Tajbakhsh to ensure that the substance of the pretrial memorandum, including any arguments by law, were not stricken, and the court did find that they were zealous advocacy, but it was competent representation. The court did not strike the picture of Mr. on page 3, which the court found was public record. However, based upon Ms. Tajbakhsh's representations regarding the criminal conviction and the sentencing and the charges that Mr. pled to, Ms. Tajbakhsh represented that Mr. pled to sexual assault, attempted sexual assault, and was found by the court to be a registered sex offender. And therefore, based upon the representations by Ms. Tajbakhsh, which were not refuted by Ms. Szyc or her client who failed to appear at the calendar call, the court received the representations and agreed to remove any language that stated that Mr. inserted his body part into the child's body part, or that Mr. was a rapist, and instead replaced it with language to state that Mr. was a registered sex offender. The court further went ahead and heard Ms. Tajbakhsh's request to strike the plaintiffs that argued that Ms. Tajbakhsh stated were disclosed after the close of discovery, and I believe one of the witnesses were disclosed through the pretrial memorandum. The court did state that it would give an opportunity for Ms. to provide an offer of proof for why these witnesses needed to be present or to testify. However, Ms. nor her counsel failed to appear at the calendar call, notwithstanding service of the ex parte motion and objection. Therefore, with there being no objection or no offers of proof provided to this court granted the request of Ms. Tajbakhsh. Further, Ms. Tajbakhsh requested for attorney's fees in having to prepare and present the objection before the court. And while the court was not inclined initially to grant the attorney's fees because a calendar call is required for all parties, the court does recognize that the failure to appear to a calendar call may result in sanctions to include attorney's fees for failure to appear, especially if a substantive motion is before this court, which was served on April 2, the day prior. That brings us to today. I understand that today we do have trial. I understand that Ms. notwithstanding the fact that she already filed a pretrial memorandum, has filed a second trial brief on April 17, 2024. And Ms. Szyc in her trial brief talks about ex parte communication pursuant to Rule 2.9. This court is very well aware of the Nevada Code of Judicial Conduct, which is why this court did not make any ruling on any ex parte motions that were filed until it was before the court here on JABS with the tapes rolling so that both parties would be present. It is this court's expectation that counsel would abide by this court's orders and show up to the calendar call to a hearing, especially if there's going to be a substantive motion addressing witnesses and pretrial memorandums. The court finds that Ms. Szyc's failure to appear at the calendar call is a violation not only of this court's orders, but is also a failure for the counsel to be prepared to diligently represent her client. It is a travesty that counsel failed to appear at calendar call, which resulted in rulings being made without counsel being present. The court recognizes that this is not the first time that Ms. Szyc has failed to appear at a calendar call or a substantive hearing. In the companion case, Ms. Szyc also failed to appear in a substantive hearing, which resulted in Ms. Szyc having to file a motion for reconsideration, which this court did give her the benefit and did grant. The court finds that this pattern of behavior of failing to appear for hearings is significant, especially when considering the gravity of this case. Notwithstanding, this court will go ahead and review the plaintiff's trial brief in open court because this court has at all times rendered its rulings and its decisions on the record in front of both parties, to the extent that the parties show up at their hearings. The court further finds that Ms. Szyc's allegations that this court is providing special treatment to the defendant is unfounded and baseless, as this court just said. This court conducts its hearings, and it is not this court's responsibility to chase the attorneys down and to remind them to show up for their hearings. If you receive a hearing date, you are expected, as an officer of the court, to show up to your hearing date and to diligently represent your client with preparation and skill and competence. It is not the responsibility of this court or this court staff to contact attorneys and chase them down. This court does not contact attorneys or chase them down, especially considering the gravity of cases and the weight of calendar cases that this court has, especially at calendar call, where this court has several cases to be heard within a very short amount of time to prepare for trial. Just as the court stated, the December 19 hearing, this court was of the impression that that matter was also vacated, so this court was seeking clarification on whether or not it was vacated, because the substance underlying the December 19 hearing had already been addressed by this court at the August 31, 2023 hearing. The court further finds that with regard to the Ms. Szyc's most recent pretrial memorandum, Ms. Tajbakhsh filed an objection thereto, which was filed on 4/17, while Ms. Szyc filed her pretrial memorandum, her second trial brief on 4/17 at 7:25 a.m. Ms. Tajbakhsh filed an objection thereto a few hours later at 6:35 p.m. This court has reviewed both the trial brief that was filed for the second time by Ms. Szyc, as well as the objection filed by Ms. Tajbakhsh. The court does note that Ms. Tajbakhsh adequately quotes the Nevada Rules of Professional Conduct 1.3, which requires diligence of the attorneys, that a lawyer shall act with reasonable diligence and promptness in representing a client. The court does note that Ms. Szyc had a duty and has a duty to remain diligent in her representing her client. While she filed her substitution of counsel on or about February 14, 2024, Ms. Szyc failed to appear for the calendar call 2 months later on or about April 3, 2024. The court does find that the trial management order was properly served to the parties, and therefore the attorneys are responsible for showing up. The court further finds that Rule 3.3 of professional conduct requires candor towards the tribunal, and that neither counsel shall make a false statement of law or fact to the court. The court is very well aware of this matter, and counsel's allegation that this court is providing preferential treatment, or that this court is responsible for chasing down attorneys to contact them to remind them to attend at hearings, borders on violation of candor towards the tribunal. The court further finds that this court has at all times given both parties an opportunity to represent their clients and to request their prayers for relief if and when they appear at the duly appointed court-ordered times for the hearing. The court further finds that failure to appear at calendar call, as stated in the evidentiary hearing management order, may result in case conclusion sanctions consistent with EDCR 5.605D and EDCR 5.102M, wherein, based upon that is why this court granted Ms. Tajbakhsh's request for limited attorney's fees for purposes of making her arguments at the calendar call, which was also her motion. At this point, I wanted to put this all on the record because this case is very important to both families and to me. Significant time has been invested in this case. I've had the opportunity to meet with both parties on this case. We have waited for this day to have the evidentiary hearing. I requested for CPS records, and I did ask for an update of CPS records because I did provide both counsel with the preliminary records that I received at the time. I just received it right now. I have not had a chance to review it. I can, during the break, give this to counsel. Of course, I will not review it until, of course, I've given counsel an opportunity. But I would presume that those records are simply the final disposition, because at the very first hearing about a year ago, I requested for CPS records, and at that time, the records that I received that I shared with counsel at the May 18, 2023 hearing did indicate that there was a substantiation against Mr. for child abuse, sexual penetration as to the elder, Miss, as well as plausible risk of sexual injury as to the subject minor in this case. At the time, those were the preliminary records that were produced to this court. I produced those to both counsel, which is why I've asked if there was a final disposition. Later on, I will go ahead and provide that to counsel so you can get it. I note that because, as we're all aware, when we're looking at the 125C best interest factors, not only is domestic violence one of the matters, but child abuse is one of the matters. I'm well aware of those factors. Of course, the burden will be on counsel to prepare your case and present your case accordingly. Now that I've made the record established, I will entertain very brief arguments, not to regurgitate any of this, but with regard to the witnesses. Ms. Szyc As I stated at the calendar call, if you provided me with an offer of proof, I would have liked to entertain it. However, you failed to appear at the calendar call. In the interest of hearing the evidence on a case such as this, with the gravity of, not even allegations at this point, with the gravity that occurred that was found by the criminal court, I am inclined to allow witness testimony. However, I have to give you an opportunity to make your offer of proof and give Ms. Tajbakhsh an opportunity to make her objections on the record.
Thank you, Your Honor, and I would just like to briefly address my failure to appear at calendar call, not making excuses, but just addressing my failure to appear. With respect to the close of discovery, as the court noted, my notice of appearance was filed on February 14th. I believe the closure of discovery in this case was March 1st, so I got into the case about 2 weeks before the closure of discovery. I didn't actually obtain this file from prior counsel until about 2 weeks ago. Something that my opposing counsel is aware of because I made her aware of the fact that I didn't have the file on my client's deposition, which I will note for the court was taken after the close of discovery on March 7th. I will also note for the court, if we're making issues about things that have occurred after the close of discovery, counsel filed 2 supplemental 16.2 disclosures after the close of discovery. So if we are addressing concerns about witnesses being noticed after the close of discovery, this isn't something that has occurred just on my side of the aisle. This is something that counsel has also participated in, including taking my client's deposition. At my client's deposition, at least 2 of the witnesses that I noticed, testimony was provided by my client at her deposition, and I was not aware of the fact that they had not been noticed in a 16.2 until I received the file from prior counsel, because I didn't have access to the 16.2s that had been served in that case, or by my predecessor, until I received his file.
Where did you receive the file?
Mr. Schneider, and I received it about 2 weeks ago.
Okay.
So as I was going through and trying to prepare and speaking with my client and getting copies of things that she had and trying to figure out what had been done, in abundance of caution and talking to her and looking at the copy of the transcript of the deposition, when I served the 16.2 that had the witnesses named, I named them, and I wasn't even sure if that was the most recent copy of the 16.2 that had been produced by Mr. Schneider's office, and it wasn't until I received the file that I realized that that was the most recent copy that he had served when I named those witnesses. So to explain why there was a late disclosure of witnesses, but
that explains the late disclosure of witnesses. I appreciate your candid report. That does not excuse the failure to appear at calendar call, which is something that you would have received through, you can check through Odyssey.
So,
and I trust that as counsel you will check to see when your next court date is.
So when I filed my notice of appearance, just in candor, the court is aware of the case ceilings, I actually couldn't access the court filing system for about a week. So I told my assistant when I filed, like, hey, log in. And when my client said, hey, my next court date is the evidentiary hearing date, she didn't give me the calendar call date because Mr. Schneider didn't give her the calendar call date. She didn't have a copy of the trial management order in the documents that I received from her. So when I got on the case and filed the notice of appearance and I said, hey, check all upcoming court dates, we had the evidentiary hearing date, that was on calendar. We were logging in, couldn't get in, and it's one of those things that just, we couldn't get in for a week, we didn't check, and because we couldn't get into the Odyssey system because of the sealed cases, and not all departments have a calendar call, so it is just a slipped thing.
You couldn't get in for a week, but you filed your notice of appearance February 14, so a week from there would be about February 28.
I'm aware, but I had the calendar call date on calendar, and then like it wasn't one of those like go on and download all the files because we were diligently just checking, and so because
I'm giving you the opportunity today.
And I am owning that yes, like I should have made sure that I had all of the calendar, but because not all family court departments have a calendar call date, I didn't think about it. I didn't think to check.
And you received the motion that Ms. Tajbakhsh filed on April 2nd.
The ex parte motion? Mm-hmm. Yes, but there wasn't a notice of hearing for a calendar call in the ex parte motion. She was just addressing the briefing.
Yes. Okay.
Yes. So, like, had there been a notice of hearing date, or had I caught that, I absolutely would have been here. I'm not one to not appear for hearings like that. Like
I know this is a second hearing substantive hearing that you failed to appear for, but
right,
in the companion case, which is separate.
But and just for the record, like that wasn't I didn't fail to appear. That was my client who was pro per who failed to appear. Like we're making a clear record. Like when my client didn't have counsel.
I want to
yeah. So like let's just like so not I as an attorney failing to appear. Like my client was appearing pro per. She failed to appear for a hearing, and we filed a motion for reconsideration when she had counsel. So,
okay.
Like,
so I just want the record to reflect that, Ms. Szyc, I appreciate your candor to the court and your accountability.
Yes.
But, you know, I have a duty to keep the record very clean.
Yes.
And so if there are statements that are filed in your documents that are accusing this court of having any ex parte communication or violating any rules of judicial professional conduct, I must ensure that the record clearly establishes that at no time has this court engaged in any ex parte communication. Every decision that this court has rendered has been on the record with this red line on.
And Your Honor, I want to clarify that also. I was not attempting to accuse this court of, I just wanted to make clear, my client's perception was that in the December hearing, the court called opposing counsel to say, hey, why aren't you appearing for this hearing? Her question to me was, when we missed a hearing, why didn't we get a phone call? So in the zealous advocate for my client, when that's a question that's being asked, I'm raising it in the briefing.
Not a problem. And
Right?
that one was this court's miscalendaring because my note said it was vacated.
And
Everybody
something
said
that
it was
I didn't have the
vacated.
benefit of knowing because I
Yes.
wasn't there, and obviously
That's
she
not a
doesn't
problem.
understand. So
Sure.
if we're making a record, like that was included in the briefing, because she was like, well, they got a phone call, so why didn't we? That's a question that I can't answer.
Correct. Yeah,
So-
that was because this court mismanaged. It shouldn't have been on calendar anymore.
So and so to the extent that it appeared that I was accusing you of an impropriety, that was not it. But when I'm asked a question and I can't answer it, I in the zealous advocacy, I'm going to raise it in the briefing. So
And that's why I allowed for your pretrial memorandum. I allowed for the substance to be there. And again, I mean, you guys are going to utilize your time. If you're going to utilize your time arguing over what's in the PTM, it's not evidence.
And that's why in my
Evidence
attempt to,
on this
when
case.
in watching the video of the calendar call, when you said you would allow me to make it proper, I was hoping that I could present the evidence, you could read it. I saw that counsel filed an objection. If you have a ruling, I'll submit it. And if I'm allowed to call them, they're prepared to be
Sure.
called.
My
If
interest
not-
is to hear cases on the merits. Of course, the most important witnesses in this case are the two parties in this matter that I'd like to hear from. But at this point, you know, time is rolling, but I will allow you to make your offer of proof of who you're seeking to propose.
And I'll stand by essentially the offer. The purpose of me filing that briefing with respect to the witnesses was my offer of proof. I'll stand by what's in the documents.
Okay.
Unless you need to hear more from me, but I'm prepared to submit it on the briefing.
Okay, and they will have very brief testimony, and the purpose of their testimony?
Is limited to what's in the briefing.
Okay, thank you. And Ms. Tajbakhsh, I did review your objection.
Thank you, Your Honor. Just really quickly, I do see one of the witnesses up there. Can I hear what's going on in the courtroom?
Shouldn't be able to, Madam Clerk, you're muted, right? They can't hear us.
Yes, they can.
Okay, thank you. Just wanted to make that clear, Your Honor. With regard to the witnesses, this court properly strike the witnesses that were disclosed. There was no real offer of proof in the briefing. It just says they're going to testify to the facts and the circumstances of this case. That's not really an offer of proof, Your Honor. The people that were identified are either family members with cumulative evidence. They're going to try to testify to hearsay matters. I'm assuming, again, we don't have a clear offer of proof in the briefing. With that being said, just to clarify the record, close of discovery was March 4th. Opposing party's deposition was taken on March 4th. With that, I also offered to send over whatever we had in the file to Ms. Szyc during the deposition. I was never requested to send that over. And so there's been so many filings and so many things happening in this case. Those witnesses will not provide any kind of testimony that's useful at this point, given what's in the briefing. I would ask that we save our time for the parties, the witnesses that have been properly disclosed ahead of time. The other issue I do have is that Mom has identified Ms. Machancy Kramer as one of her witnesses. During her deposition, she did testify that at the beginning she sought her advice as counsel, did hide behind the attorney-client privilege, so she did not testify as to the conversations that were had. So I would say under Nevada Rules of Professional Conduct 3.7, an attorney shall not act as a witness in a case. She has rendered advice in this case. I do not believe that it's appropriate for her to be testifying today.
And that's Ms. Kramer?
Yes.
I don't even see her in the brief. I see for maternal grandparents, correct?
Yes.
Okay, and maternal grandparents lived in the home as well? They're going to testify, it appears here, they're seeking to testify regarding witnessing domestic violence?
Yes, but they don't live in the home.
They don't live in the home?
No,
They
they're-
at one point lived in the
Yes.
home? Okay, no longer in the home now, they're in Minnesota. So they're seeking, you're proffering them to testify to domestic violence that they witnessed during the marriage when the child was born?
Correct.
In front of the child, or with the child being born? Okay.
That's correct.
All right, and then the other one that you're proffering is Mr. Cody James Bell. And Mr. Cody, I believe Mr. Cody is the one that was
He was
listed in the CPS records.
yes, and he was present on the night of the incident, and he's going to provide. And if this is not clear, he was going to provide testimony that Mr. offered him drugs the same night that he offered drugs.
I recall reading his name in the CPS records with that same disclosure. So, okay, so that is Cody. And then Patricia Peterson is the best friend that lives in a home, correct?
Correct.
She continues to live in a home?
Yes.
With the parties. So those are the four that I see that you proffered in your pretrial memo, in your second brief. I didn't see anything about Ms. Kramer.
Your Honor, the ones when we came to court on the calendar call,
Yes.
Ms. Kramer was there,
Okay.
and I believe Ms. was there and Nova was there. We did strike the remaining ones. The trial brief that was filed a few days ago was asking for you to set aside the order of striking those witnesses for that reason.
And
Again, they were all disclosed far after the close of discovery. I understand Ms. Szyc just came on the case a few months ago, but at this point it's been pending for 14 months. That shouldn't have been the first time that we've heard about those witnesses.
And well, in Your Honor, but specifically my understanding of watching the calendar call video, the witnesses that I addressed in my brief were the only ones that were asked to be stricken. The other witnesses were properly named based on my review of the previous 16.2 of the file. The parties and Ms. Kramer and another witness, Nova, were named initially.
Okay. All right, and I know Taylor is testifying, but I want to make sure we have enough time. You guys only have 3 hours each.
Aware.
So who are your primary witnesses right now?
So my essentially though I would like to start with her testimony just to get it done so that she can be released. If I'm allowed, I would call Cody. I don't anticipate that his testimony would take very long. And then again, if allowed, I would call and resolve that very quickly. Then I would call Ms. Shancy.
Cody, maternal grandparents, the defendant, who did you say was another person?
Ms. Shancy, and then
Who's Ms. Shancy?
Ms. Kramer.
Ms. Kramer, the attorney.
Yes.
That's the one that she objects to based on attorney-client privilege.
Yes. With respect to Ms. Kramer has witnessed many other incidents besides there's testimony that she can provide. She is and she is and she's a member of the family that can provide testimony beyond her conversations with.
So how are we going to draw the line between the testimony that she's providing that's as an aunt or as an attorney?
Well, I mean, I think it's quite simple that she can't testify to any conversations that she had with a woman and limit it to anything that she's observed.
And Your Honor, she's been drafting the pleadings in this case up until very recently.
Oh, she's the one that drafted the pleadings
Yes,
that
Your
you're
Honor.
talking about. You mentioned the
Yes,
Ms.
Your
Kramer
Honor,
before.
and we've mentioned it in the pretrial memorandum as well.
And pleadings that were stricken by this court.
The previous one, and then the pretrial memorandum that was implicated.
I do find that Ms. Kramer, if she is the one that is involved in this case and is drafting pleadings in this matter, it's one thing to be an attorney and an aunt and maybe talk about a traffic ticket, something unrelated. But if she has been involved in this case, representing and drafting pleadings in this case, and if she's going to be testifying, that's going to be violating the attorney-client privilege. I don't know how I can draw the line between, okay, you can testify about this, but not this. If she knows the information, she's one person. So at this point, I am interested in taking testimony. Cody's testimony, I do recognize that it was noticed after discovery, and I do recognize, Ms. Szyc, your testimony that you just received the file. Because Cody is not a surprise witness per se, because he is listed, and I believe some of the information here with the Department of Family Services, I will go ahead and allow limited testimony from Cody. It's not going to take much time.
No.
The maternal grandparents, my challenge is testimony must be in person, so I can also assess their credibility, and so Ms. Tajbakhsh can cross-examine and also assess this court's credibility, or this court assess their credibility. Cody's in person?
Your Honor, no.
Cody's not in person?
No. He was traveling here. He lives in Phoenix, and he was traveling here in the vehicle that was then broke down. There was no other way to get him here in time, so he is going to be testifying from, I believe, a hotel room.
Okay, and that will, I do allow video alternate testimony if there's a stipulation by counsel, especially if it's expert witnesses, talking about, I have expert witnesses that are from Washington or from other states, and it's not an issue. But if credibility is an issue, and if there's going to be an objection, I'll have to sustain that objection.
That's understood. Unfortunately, there wasn't even a time for me to address this. It happened at 11 o'clock. So,
if Cody was here, I would have allowed Cody to testify in person, unless there's a stipulation from Ms. Tajbakhsh to allow his video testimony.
No, Your Honor, there's been no notice of audio-visual for any of the other witnesses either, so we
Are
are
there
objecting.
audio video, counsel?
they live in Minnesota, and I wasn't sure that the court was going to allow their testimony. So,
Okay.
yeah.
All right. And
But
the rules do
Cody was on
require-
his way here when his vehicle broke down. So,
Okay, and the rules do require that there has to be notice by audiovisual means
I'm aware.
that must be filed. And
yes.
so the court does find that there has been no notice of audiovisual means that was filed, and therefore the court will be denying any audiovisual testimony unless by stipulation of counsel. If there's no stipulation on the record for any audiovisual, witnesses proffered must be in person. With that said, do you have any, you do have in person?
In person,
Okay.
yes.
All right, so we have, and we have your client.
Yes, and Your Honor, I would like to be heard on Ms. Kramer because again, there are things that she can testify to that are not related to any participation as the attorney-client privilege. Because again, she's a member of the family, like more part and parcel than any participation that she would offer as like I think there is a distinct line that can be drawn here because there is testimony that she's going to offer that is not at all related to any conversation that she had or potential assistance that she has given in this case, specifically related to Mr. potential unemployment and his work and like participation and conversations that she had with Mr. and his union employment as related to his assistance with her in another case when she was representing another sister. I think that's key testimony that Your Honor should hear. And so I think even if you limit it only to that, I think it's important that you hear from Ms. Kramer.
Okay, from family members.
Yes.
Or family perspective.
Yes.
Ms. Tajbakhsh.
And Your Honor, I disagree. During Ms. deposition, they hid behind attorney-client privilege for the conversations that were had. I asked about them. You can't have it both ways, Judge. You know this, I know this, the courtroom knows this. You can't have it both ways. Given the way these pleadings have been written in this case, given the allegations that are made, there is no doubt in my mind that Ms. Kramer is unable to separate what conversations that she had versus how she advocated for her client or for her sister in this case. There's no way we're going to be able to decipher between what part of it was advice, what part of it wasn't advice. Besides, and most of what I'm hearing is going to be hearsay about my client. So my client can testify to it. Ms. Kramer's testimony is not only just going to be inflammatory, it's going to be, frankly, a waste of this court's time. And you are running the line between the ethical obligations she still has in this case and the fact that she has been involved up until today in this matter, Your Honor.
Has she filed a withdrawal?
Ms. Kramer has never appeared in this case as an attorney, for the record.
She's drafted the pleadings.
She's assisted, yes.
Okay.
Absolutely. But again, with respect to the deposition, Ms. Tajbakhsh asked my client as to any conversations that she's had with Ms. Kramer with respect to this case. That is not the testimony that I would elicit from Ms. Kramer, and as to that regard, it was appropriate for Ms. to respond and attorney-client privilege.
So how do you intend to separate the two? If she's her sister, she's enmeshed in this case, she's also drafted much of the pleadings here that were very, just extremely heated. Again, charged pleadings.
Again, I think that there can be an instruction because sister, not in their distinction, these parties were married for several years. Ms. Kramer has experience that is not related to this case. At deposition, she only sought to elicit testimony directly related to the attorney-client privilege. She said, what did you discuss with Ms. Kramer? Not anything else. Like, there was no other attempt to question her about anything other than the conversations that were had directly related to this case. Essentially, the testimony that I would attempt to be eliciting from Ms. Kramer, not related to conversations had or protected by privilege, are related to Ms. Kramer's knowledge with respect to Mr. work history and experience, because I potentially will attempt to establish that he is willfully underemployed based on experience that Ms. Kramer has and knowledge that Ms. Kramer has of Mr. Knowledge of the union and how to be underemployed.
So her testimony is going to speak to the
expert
financial
testimony
matters.
she wants to provide.
Okay.
My apologies. That's
So
expert
my
testimony.
understanding that her testimony is going to speak to the financial matters of the matter.
Correct. Which are not related to conversations that my client and Ms. Kramer have had.
Okay,
There's no
well,
privilege there.
And Your Honor, that's how are we going to prove that? That they've never had these conversations in 14 months that this case has been ongoing.
That's a conversation, but I specifically would be eliciting testimony that Ms. Kramer had with Mr.
at this point, it's going to be focused more on the financials. My primary concern is custody. I want to ensure that we get enough testimony today regarding custody. I'm concerned that we might not have enough time to do everything. I want to make sure that we have addressed the custody first and foremost. If at any point we need to continue this to give another half-day setting for the financials, then perhaps we can address it at that time. But right now, my focus is on custody. If she's not going to be speaking to custody per se, but more so on financials, as you guys know, the rules require that I first address all custodial matters before I even shift gears to addressing the financial matters. So at this point, I am going to deny her testimony today.
Your Honor, I ask that you do that without prejudice so that I can reserve the right to call her on
I
that.
was just going to say that.
Thank you.
It's without prejudice, because right now my focus on the crux of the matter with the time that we have is I want to hear custodial matters regarding 125C00357 sub 4. So it's without prejudice at this point, okay?
Thank you.
You're welcome. Okay, are we ready to proceed? I'll give you guys a couple minutes to gather everything together. I'd like to do a hard start at 10 o'clock. This matter was all preliminary, so this didn't count against your time. But when we start at 10, we'll go straight through for 2 hours till noon. Madam Clerk, what time would you, I want to give my staff their lunch break. Can you go till 12, 12:30? 12:30? Why don't we, if you guys are fine, we'll go till 12:30, so we can go 2.5 hours. And then we'll break 12:30 to 1:30, and then take it 1:30 till 4 o'clock, 4:30, I believe. So I will be accounting for your time. 3 hours will be on each side. So Ms. Szyc, this is your case, so you will have 3 hours to present your case. And then Ms. Tajbakhsh, you'll have the following 3 hours. Recognizing, of course, that during your time, if you're doing cross-examination, it counts for your time. Okay?
Wait, just to be clear,
If you're speaking, anytime you're
direct
speaking-
and then cross, not Ms. Tajbakhsh's cross for my direct.
No, anytime
Okay.
you speak. So
Yeah.
if you're gonna cross-examine her client, that's your time because you're
Yes.
speaking.
Thank you.
Okay, and I don't know if you're aware, but in this court, you have the option of doing opening arguments, that's fine. I don't do closing arguments. I prefer closing briefs, and with the VC and proposed findings of fact, conclusions of law with the corresponding VCs, video sites. It's up to you guys when you want to submit those closing briefs. It can be on any chamber's day. You just have to agree whether it's next Monday, 2 weeks out, 3 weeks out, the most I'll go is 4 weeks out. Because from the date you guys submit your closing brief, I'll put it on calendar about 30 days out for day 2 evidentiary hearing decision. Okay? So that kind of helps you with allocating your time. I really want to utilize all of this time on giving the evidence and testimony. Okay? All right, so.
I'm gonna
any
just
other
step out in the
preliminary?
hallway and get my witnesses together and
Not a problem. We'll take a brief 5-minute break. We'll start sharply at 10 o'clock.
thank you.
Thank you all.
All right.
Thank you. You may be seated. Okay, I see we have a number of folks in the gallery now.
Yes, Your Honor, none of these individuals are named on the witness list.
Your Honor, this is a sealed case. I would ask that they be removed from the courtroom. This has been a sealed case for over a year now. And I was actually, when I had conversations with your department, Ms. Szyc was notified about Mr. Falcone being here and everything. It was confirmed that the case is still sealed. So I would ask that these people not be allowed to testify. They have their phones, or not testify, observe. They have their phones. They could be in contact with other witnesses. It's a very, very private case. It's a sealed case for a reason, so I'm asking that they not be present in the courtroom.
I mean, Your Honor, in light of the fact that our Nevada judges is here, and it's your call.
Okay. So why are you asking them to testify? Why are you?
They're not here to testify.
I understand.
They're
Are they
friends. They're friends of Miss. She is about to get on the stand and give testimony. They're here to be supportive to her.
Okay, so they're here solely to provide support to Ms.
Correct. They're not going to be here the entire time. They're just supportive of Miss Harris.
Okay. So, can we identify their names, please? I can talk with them.
Hi.
Go ahead. Please stand.
Can you just stand and say your names, please?
Yeah, my name is Cannon Patton.
Ms. Patton, thank you.
Trish Peterson.
Ms. Peterson, thank you.
Adam Abu Hatir.
Was that
Adam Abu Hatir.
Mr. A? Okay, thank you. Okay, so I understand the 3 of you are here to provide support to me.
Yes.
Okay, do you understand that this is a sealed case, so any conversations, anything that you observe in this courtroom is not to be shared or discussed outside of this courtroom?
Yes.
Are you close friends with Ms.?
Yes.
Okay, so I will allow very briefly for their testimony, for their presence to be here, only for Ms.'s testimony. After that, they must all leave. I do recognize the nature of Ms. testimony, and I also ask our Nevada judges to ensure the protection of Ms. That her face will not be shown and that her name will be covered. This testimony is very vulnerable, and we want to definitely ensure that there are protections in place.
We typically do reach out to victims of this type of crime, and we're in communications and we're complying with their requests.
Thank you. I appreciate that. Thank you for your sensitivity to Okay, so considering the nature of Ms. Perry's testimony, I will allow the participation or the observation of her 3 close friends solely for purposes of her testimony.
And Your Honor, just to make a record for my client, again, this is a sealed case. Just having our Nevada judges here is a very specific rule that doesn't permit public access to the courtroom for a sealed case, just to have the media. That is it. This isn't a short case that they get to come in and watch and just kind of egg on and sit there and observe. There's a reason this case is sealed, and this is over my client's objection and over my objection, Your Honor.
Okay, and I recognize that, and again, I'm narrowly tailoring this due to the heinous, and I don't have to watch my words, due to the heinous nature of the crime that we're dealing with and the fact that Ms. will likely, I'll ask Ms. Szyc to give me an offer of proof, but I'm presuming that Ms. will be testifying to the rape that she is going to describe that she endured by Mr. Fess.
That's correct, Your Honor.
And due to that, and I understand that Ms. though she's now 18, she just recently graduated from high school.
That's
Is
correct,
that
Your Honor.
correct? So during this time, she was a child. She was 17 years old during the time that this occurred. And actually, at the inception of this case, she was still a child because she was still in high school. So due to the vulnerability and the sensitivity of Ms. testimony and what she will have to be describing today, I will allow her support system to be here briefly for purposes of supporting Ms. in providing the testimony, with the understanding that once she leaves, her support system must leave as well.
Thank you, Your Honor.
And Your Honor, very briefly with the offer of proof now that it's been given, is the court going to take judicial notice of the criminal case in the best evidence rule, given that the criminal case is the best evidence and Ms. is not a party to this case? She graduated high school last year and she is 19.
Didn't she just graduate this year?
No, Your Honor, last year. She's 19 years old, she'll be 20 this year.
Okay, thank you. So yes, I presume there's a request for me to take judicial notice of the criminal case?
Yes, Your Honor.
Okay, and for the record, I believe there were 2 of them. Can you give me the case number so I can put it on the minutes?
My client's criminal case from last year?
That's correct.
C-23 374524-1.
Madam Clerk, did you get that? We're taking judicial notice of case number, you want to read it out?
I need C23745.
374524-1.
And Your Honor, I would ask for specific findings as to the witness and the offer of proof that were provided, since there is the underlying criminal case that is the best evidence of what transpired and what occurred. I would like to have specific findings as to why Ms. Perry's testimony would even be relevant at this point to when we can just take notice of what already happened. Why are we regurgitating it today?
Okay.
Your
One
Honor.
at a time. Let me make sure I have the case number on the record correctly. We're taking judicial notice of case number C23-3745-374524-1. Is that correct?
374524-1. Yes, correct.
Okay, excellent. All right, and Ms. Szyc, your offer of proof?
Yes, Your Honor, because Ms. was a young child at the time that Mr. and Ms. began dating and then got married. Mr. raised her from the time that I believe she was 8, and I think this goes directly to the best interest factors. I think this goes directly to the domestic violence. I think this goes directly to the 125C factors that the court needs to consider in making a determination to the presumption. And it's my burden of proof, and it's my case in chief to put on. I think there's things that you need to hear directly from the victim that you're not going to be able to discern from just taking judicial notice of the criminal case. Further, Ms. Perry stood in the courtroom in the criminal case, and she's going to give essentially the same testimony that she recited at the sentencing that the court weighed. And essentially, when I call Mr. Fess during my case in chief, I'm going to go weigh into the sentencing factors that the criminal court gave him with respect to his parole and probation and the requirements that he had with the tier 3 sex offender, because I think it's important that you hear those things too. I think you need to hear Ms. testimony to know why the court made those decisions, because I think it's important for you to understand why we're here. And those things all go directly to the 125C factors.
Any opposition?
And Your Honor, I would like the court to know I'm not, in no way am I saying anything about the victim here, but 17 years old and a young child are 2 completely different things. The age of consent in Nevada is 16. I'm not saying she consented. I'm not saying anything about that incident. I am saying we have a 7-year-old boy, a boy who just turned 7 yesterday, who my client has had some custody of for the last 7 months, and an incident that happened when somebody was 17 years old. With that being said, there is a criminal case. We're not here to try the criminal case again, Your Honor. We're not. We are here to determine the best interest of the young child in this case. Do we need to tell the parties not to use the child's name? for the?
No, you can.
Okay.
They're gonna bleep it out, but I just feel more
Perfect.
comfortable
Okay,
not
thank
to
you,
use the
Judge.
names.
We are here to determine custody of the young child, so to spend hours and hours and hours going into my client's criminal case, his criminal plea, the court can take notice of it. The best evidence is what's in front of the court right now, and it's not gonna be regurgitating testimony again here today.
Well, the court can certainly take judicial notice of the criminal case and the findings of fact, the conclusions, disposition thereon. The best evidence that this court has is the testimony in front of this court, so that this court can assess credibility, not just of the witness, but of the parties. I personally enjoy having the trial in person, because not only can I assess the credibility of the witness, but I can also assess the reactions of the parties when the witness is testifying. I gathered much information from that, oftentimes when a witness is testifying, and the reactions of the parties to the action. So I'm going to find that it is in the, my focus is not to retry the criminal case. I absolutely don't want to retry the criminal case or regurgitate any of that. My focus is on his best interest, and my focus is on whether or not these two parents here should have joint, or whether Ms. Szyc is going to meet her burden of proof to try to establish that her client should have primary, if not sole custody, and that Mr. is not entitled to that. The burden is on Ms. Szyc. The court will grant the testimony of Ms. The court does find that it is the best evidence for this court with regard to Ms. Perry, who, it's my understanding that Ms. was raised in the home with Mr. at the young age of 10 until she turned 17 or 18, until the incident occurred.
That's correct, Your Honor.
So, and this was, they had a relationship as a father to a daughter, and daughter to a father.
That's correct.
That's my understanding of the offer of proof, and therefore I'm here to assess parenting, I'm here to assess the safety of a child, and I'm here to assess credibility. And so the court does find that Ms. testimony will be credible and directly pertinent to the findings that this court must make pursuant to NRS 125C0035 subsection 4. Okay, so at this point, we're ready to proceed with Ms. testimony?
That's correct, Your Honor. She is my first witness. And if I may step into the hall. Thank you.
Thank you for joining us today. We're going to have you stand and raise your right hand and swear in, okay?
You do solemnly swear the testimony you're about to give in this session shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Okay, can you please spell your name for the record? Okay, thank you. And how would you like us to address you as Ms. What are you most comfortable with? Okay, all right, thank you for joining us today. You're going to be asked a series of questions today. If at any point you hear the word objection, please refrain from answering the question until I make a decision on whether or not you can answer, okay? All right, and if you don't understand the question, feel free to say you don't understand, okay? All right, and let me know if you need any breaks. I do know that you're aware of our Nevada judges who were taping today, but they are covering your face and protecting your privacy. And we're allowing your friends to be here solely for the purpose of supporting you. But eye contact should be either with the attorney speaking to you, or you can look to me. Please refrain from making any eye contact with any of your supporters or anybody else, okay? Thank you, ma'am.
All right. Did you state and spell your name for the record already? Yes. Okay, just make sure. What is your relationship?
She's my mother.
Okay. What is your relationship with?
We used to be my stepfather.
And when did your mom start dating?
I was about 9 years old.
And was there ever a time in which you lived with?
Yes.
When did you move in with?
When I was 9 years old.
And did you live with him continuously?
Yes.
Till what age?
Until he moved out when I was 18.
Sorry, you said 18?
Yes.
And when you first moved in with him, who all lived with you?
Just my mom and
And at any point did anybody else join your family?
my mom had a baby about a year or 2 into the relationship.
Is that your little brother?
Yes.
And what's the age difference between you and him?
He's 7 and I'm 19.
So about 12 years?
Yes.
Can you describe what your family dynamic was like before born?
My mom's had a couple of boyfriends. So at first it was just one of the boyfriends. So just normal, like every other boyfriend she's had.
And after she was born?
And after she was born, I realized like this is my new family now. So I started to like open up to and get close to them.
Sorry, but I can't hear her at all.
Can you speak louder now?
Yes.
Thank you.
And so, I'm sorry, did you say you started to open up?
Yes.
And what do you mean by open up to?
I just took him in as my dad. I looked at him as my father.
Okay. Were there times that you and Jason would do things just the two of you?
Yes.
Like what?
Just normal father-daughter stuff. We'd get ice cream. We'd go to Build-A-Bear. We'd go get food.
Would he discipline you if you got in trouble?
No.
That was something just your mom did?
Yes.
Okay. At any point as you were growing up, did your relationship with
When I was 17,
what happened when you were 17?
Jay, do you want me to tell you the whole story?
Sure.
Please
Okay.
speak up if you're ready to.
Okay. My family was over having just a get-together, and everyone was drinking, sneaking beers into my closet for me.
Was this the first time Jason had ever given you beer?
No.
When's the first time he gave you beer?
It was my niece's birthday party. And
How old were you?
oh, I don't remember, about 13, 14.
Did your mom know about that?
No.
How many times did he give you beer before the night you're talking about?
I'm sorry, I don't understand the question.
Sure. So I imagine let me rephrase. You were starting to tell me about a change in your relationship with him, correct?
Yes.
I imagine that you're speaking about a specific incident that occurred in October.
Yes.
And
Objection Foundation.
If you want to rephrase.
yes, thank
She
you.
didn't say anything about October.
Sure. Are you talking about a particular event that changed your relationship?
Yes. And around.
Hold on. Let me ask you some questions, okay?
Sorry.
Is that a particular event that caused you to have to go to court and talk to a judge before today?
Objection, leading foundation.
Sustained. You can rephrase it.
Yes.
One question at a time.
I asked you about an event. If there was anything that changed in your relationship with Jason, you said yes. Do you recall that?
Yes.
Can you tell me, without going into details, what the event was?
I was having a house party. He gave me beer, cocaine, and he put it inside me when I told him no multiple times.
Okay, so you're talking about the criminal event.
Yes.
Okay. I'm going to ask you some questions about that. But before we get there, you started to testify that he gave you beer when you were 13 or 14 years old.
Yes.
Okay. Was that the first time that gave you beer?
I don't remember.
Okay. How many times before, I'm going to call it the criminal event, how many times before the criminal event has ever given you beer?
He's tried to give me beer, but my mom always says no.
Now, you mentioned that you were having a party. When did the party happen?
I just know it was sometime in October.
How old were you when the party happened in October?
I was 17 years old.
So what year would that have been?
2023,
Last year?
2022. I'm not sure what year it was.
Okay. What year did you graduate high school?
2023.
Okay,
So it was 2023.
did it happen before you graduated high school?
Yes.
And you graduated in 2023?
Yes.
In May?
Yes.
So was it the October before you graduated high school?
Yes.
So October 2022?
It was my 12th grade year, so it was 2023.
Are you sure?
No.
Okay. If I represented to you that it happened in October 2022, would you have a reason to disagree with me?
No.
Okay. So in October of 2022, your family was having a party.
Yes.
Who all was at your house?
My mother was there. A couple of my aunties were there. I was there. My childhood best friend was there.
Who's your childhood best friend?
His name is Cody James Bell.
Is Cody the same age as you, or is he older?
He's about a couple months older than me.
Was the party for any special reason, or just because?
I don't remember.
So tell me what happened at this party.
Okay, everyone was just outside listening to music, drinking beer, and he asked me if I wanted beer, and I said yes, and so he snuck it into my closet. And then the night just went on, and then we were all outside in the backyard, and everybody was out there. We were sitting on the couch outside, and he texted me, and he said, I have a question to ask you, but it might ruin my marriage. So I asked him what it was, and he asked me if I wanted to try cocaine.
Is that the first time Jason ever about cocaine?
Yes.
What did you say?
I said yes.
Did you try cocaine that night?
Yes.
Did anyone else try cocaine with you and Jason that night?
No. He asked Cody if he wanted to, but Cody said no.
Objection here, sir.
Okay.
I don't need to hear what other people said because they're not here. So you can keep your testimony, but when you said Cody said, I don't need to hear what he said. So Cody's not here, okay? Thank you.
So, did you and do cocaine together that night?
Yes.
Where?
In his truck in the driveway.
Okay. Was anybody else around while you were doing it?
No. He made sure that we were alone.
Was the party still happening while this was happening?
Yes.
Where was everybody else while you were outside in his truck?
They were in
Objection,
the backyard.
speculation.
Sustained.
Yeah, that's fair. Could you see anybody else while you were outside?
No.
What happened after you did the cocaine?
After we did coke, the night just went on like normal. And then everybody eventually started going home. And my mom went to sleep with my little brother. And me and were still awake. And then we went to the backyard. And he kept bringing me more beers.
Was there anybody at the house at this point besides your mom and
No, everyone had left.
Okay.
So me and in the backyard, and by that point we almost did a whole 8 ball, is what he said.
did you
Objection, speculation.
I didn't really hear her. What did you say, Matt? Almost did a what?
By that time, me and did a whole 8 ball, what he said to me.
Did a whole 8 ball? Is
Yeah.
that what he said to you? Okay. You said speculation?
I said speculation, Your Honor. How would she know that if it's an 8 ball, was it? What is an 8 ball?
I don't even know what it is.
Yeah.
Well, she's telling me what he said, and he is here, so I'll also state it. And then I need some foundation.
Sure. How did you learn that information?
What an 8 ball is?
Well, yes.
I'm still not that sure what it is. I just know it's a lot of cocaine. I'm assuming in the form of a ball.
Well, that evening, how did you learn those words that evening?
Someone told me about it.
Okay, so the only way you learned those words that evening is because you heard say them? Is that okay? What happened after you guys were outside?
We were outside, and I'm sorry. We were were outside and he asked me if I was getting drunk, and I said yes. And he didn't want me to go into the house because he didn't want me to wake up my mom. So I went pee on the side of the house, and then I saw him. I looked up and he was peeing and just staring at me.
And when you say you looked up and he was peeing, could you see any part of his body?
Yes, I could see.
Okay. What happened next?
After that, we sat on the couch. He asked me if I wanted a back massage. He started massaging my back. Then he slowly started lifting up my shirt and touching my boob. And then he kept trying to lay me back down on the couch, and I kept saying no. I kept saying no, no, no. And then he just kept saying, come on, you never think about it. And then he raped me. And then
What happened after that?
I don't remember, I really just blacked out. And then I just went to my room and cried. And then after that I just stayed away from him. And it was never home. It was always with my friends or at school or doing something.
Do you remember the first time you told someone about this event?
Yes.
Can you tell me when, meaning the month or year, you've told someone about this event?
It was around Christmas time, December 2022.
Who was the person that you told?
I told my best friend Jason.
And why did you tell your best friend Jason?
I was having a mental breakdown one night, and she was there.
You can't say anything that she said. Just I want to know why you told her.
Okay.
Do you have tissue for the witness?
Oh,
Marshall?
there's some right
Okay. You can take your time if you need to take a brief break, okay?
Thank you, Your Honor.
I'm sorry, what was the question?
And why did you finally tell someone in December?
I don't know. I was just having a mental breakdown. And my best friend, I just wanted to tell him. I wanted to tell somebody.
Is there a reason why you didn't report it immediately?
I was scared of because he was still living in the house.
Were you afraid that you would get in trouble if you had told before then?
Objection meeting.
Sustain, you can rephrase.
Sure. You mentioned that you're still living in the house.
Yeah.
And you mentioned previously that you were trying to stay away. What did you mean by trying to stay away?
My mom is in school, so it's used to just be me. So I wouldn't go home after school. I would go to my friend's house or just go to my cousin's house, go anywhere but home.
And do you mean you would go anywhere but home after this event happened in October of 2022?
Yes.
Why didn't you want to be home after October of 2022?
I didn't want to be at the house with you.
Can you tell me about the first time you told your mom? What happened with you and
I was at Cody's house, and my mother called me and told me that she had cheated on me. And so I came home. He was gone, and my mom told me he's not coming back this time. So I finally felt safe to tell her.
The events that happened that night changed things in your family.
Yes.
Can you tell me how they changed things?
Well, my mom is a single mother now. My mom's in school. I was supposed to go to college for nursing, but now I just mentally can't do it, so I could take a break. And we have to move out of our house. We don't have that much food in our fridge.
What about your little brother? What's your relationship like with your little brother?
My little best friend.
You pretty cool dude.
Yeah.
When you were growing up, actually strike that. Prior to that party in October of 2022, was there any time leading up to that night that made you uncomfortable?
Yeah.
Objection foundation.
Overruled.
Thank you. Can you describe an example of when made you uncomfortable prior to that night in October of 2022?
Objection vague and ambiguous.
I'm asking her to describe.
That's a follow-up from the question.
I understand Your Honor, uncomfortable. I mean, this is very broad. I'm just asking for
Okay.
specification.
If you want to define uncomfortable, we'll have her define uncomfortable.
Sure. Okay, so was there ever a time in which made you feel weird?
Yes.
Okay. Can you describe for me what weird means to you?
Weird. Actions that a father should not show towards their daughter.
Okay. Can you describe a time that made you feel that way?
One time I was looking at the backyard with my friend and I was telling her how the neighbor boy was looking at me swimming over the wall.
Can you speak louder? I can't hear you enough.
Oh, I'm so sorry.
That's okay.
There was one time when me and my friend were looking in the backyard and I was telling him how the neighbor boy would look over me at the wall, over the wall, at me swimming in my swimsuit. And I was telling my friend that that's weird. And he came into my room and he said, it's not weird. People are gonna look because you have a nice body.
And that made you feel uncomfortable
Yes,
because you looked at him like a dad.
yes.
I'll pass the witness.
At this point, I'm going to ask you questions. Are you okay to proceed?
Yeah.
Can you take a break?
Okay.
Okay. You let me know, okay?
If you need a break, it's okay.
Thank you.
Yes. You testified that Jason snuck you alcohol the night of October of 2022, correct?
Yes.
Had you ever had alcohol before that?
Yes.
Okay, isn't it true that you actually had gotten in trouble with your parents several times for drinking a lot of alcohol?
One time.
Okay. And you had actually previously been grounded for sneaking alcohol into your room?
No.
Okay, so your mom wasn't ever worried about you sneaking alcohol into your room?
Maybe one time when I was 14, but no.
Okay, so you had alcohol prior to that night then, correct?
I'm sorry, what?
I said you'd had alcohol a couple of times prior to that night, correct?
Yes.
Okay. You stated that made sure that you were alone when you guys were doing cocaine that night, correct?
Yes.
Okay, so was Cody present at that night?
Yes.
Okay, so you weren't alone.
And alone I meant away from people that would tell and get in trouble for it.
Okay. Did anybody come up to the car that night?
No. Just me and Cody.
Okay. You testified that he brought you more beers. Do you remember how many beers he brought?
In my room there was about 3. And when we were in the backyard, when I looked down there was about like 10.
Isn't it true that you were drinking out in the backyard?
Yeah.
And were you drinking in the closet by yourself?
Yes.
Okay, but you also were drinking out in the backyard with everybody?
With just Jay when everyone went to sleep.
Did anybody come look for you in your room?
No.
Okay. What's your understanding of what an 8-ball is?
Cocaine. A lot of cocaine.
Isn't it true the day after this incident you went to sushi with Jay alone? Okay. Isn't it true that on or about December 8th you went to the dealership with so that he could buy you a car?
Yes.
Isn't it true that your grandparents came into town prior to February 2nd, 2023?
Yes.
Isn't it true that you all went to dinner together during that time?
I don't remember.
Isn't it true that you hung out together as a family at that time?
Contraction form. Hung out as a family, hung out as a family, like who?
Yeah, you stated that your grandparents were in town at some point between October and February, correct?
Yeah.
Okay, and did you guys?
Clarification? Grandparents, maternal or paternal?
Oh, I'm so sorry. Maternal grandparents were there. That your mom's parents were
Yes.
there, correct? Okay. And you guys spent time. Did you guys spend time together as a family?
Yeah.
Okay. And isn't it true that was actually gone from December 23rd to 27th of that year?
I'm not sure I blocked that out of my memory.
Okay, but he was gone at some point at that time, correct?
I don't remember.
Okay. And it was around the time that you told your friend Jason about what happened?
Jason.
Sorry, what's the name?
Jason.
Jacelyn? Oh, it's a girl. Okay, I'm so sorry. I heard Jason. That's around the time you told Jacelyn what happened, correct?
Yes.
And you testified that you didn't want to tell anybody because you were scared of Jason, correct?
Yes.
Okay. When he was gone, how come you didn't report it when he was completely out of state?
I'm sorry, can you rephrase that?
When Jason was gone between December 23rd and 27th, out of state for Christmas, or just away for Christmas, how come you didn't report it at that time?
Jason was out of state for Christmas?
He was gone between December 23rd and 27th.
Well, I knew he would come back to the house.
Okay, but he was gone though. So I'm just asking why you didn't report it during that.
I don't even remember him being gone.
Okay.
Because I was probably gone out of the house too.
That's fine. Okay, understood. Prior to this incident, you said that you had a good father-daughter relationship, correct?
Yes.
And you guys texted a lot.
Yes.
Spent a lot of time together.
Yes.
You guys went and got ice cream.
Yes.
You guys went to trips, I'm assuming, as a family.
Yes.
Okay. He was there for you for many years prior to this incident, correct? Okay. You stated that he's your stepfather. Do you have a relationship with your dad?
Not really.
Okay. When was the last time you saw your biological father?
A couple months ago.
Okay. But do you talk to him very often?
Not really.
Prior to the incident that you described, would you say that you looked at like a father?
Absolutely.
Did you ever call him dad?
Yes.
Has he ever physically disciplined you?
No.
Your Honor, I will pass the witness. Court's indulgence.
I have no regret.
No, we did, okay. So no further intentions to call Ms. as a witness? No? Okay. Ms. Thank you for taking the time that you have today. I appreciate it. You may be free to go. You and her. Is she staying? She's not staying. She's going.
No, she's going.
Okay. Okay. These friends may leave now as well. Thank you all.
Thank you, Your Honor.
You're welcome.